All right, good afternoon. We are on the record. We are being recorded. I'm Judge Christopher Bates. This is Montesano Municipal Court, October 26th. And of the arraignments, it appears I have only one arraignment present. That would be City versus Daniel Gulke. Mr. Gulke would step forward to the podium. Good afternoon. Can you state your name for the record?
Daniel Lee Golke.
Okay, Mr. Gulke, you are here today for an arraignment. You are charged with assault, 4th degree, with an allegation of domestic violence. You were provided with an arraignment form today. Did you have the opportunity to read through that form?
The arraignment form.
Yes.
Yes.
Okay, I have that in front of me. And so the crime you're charged with is a gross misdemeanor offense. It carries maximum penalty of 364 days in jail and a $5,000 fine. As a defendant in this court, you have rights. You have a right to an attorney. If you can't afford one, you can apply and we can evaluate your financial status to see if you're eligible. You also have a right to a speedy trial. You have a right to a jury trial. And if your case proceeded to trial, you also have a right to hear and question the city's witnesses and have witnesses testify in your defense. If convicted at trial, you have a right to appeal your conviction. Do you understand all those rights?
Yes, sir.
Okay. Understanding the charge against you and the rights you have, how do you plead today? Guilty or not guilty?
Not guilty.
Okay. A plea of not guilty is entered. And on your form here, you've indicated you would like to represent yourself. Is that correct?
I changed my mind, Your Honor.
Okay. And so, are you currently employed?
Yes.
Okay. And what do you do?
I'm an operator, heavy machinery.
What's your monthly take-home pay?
Oh, take home? About 4,000?
Say that one more time.
Approximately 4,000.
Okay. All right. Are you paying any child support?
Yes.
Okay. What's child support look like in a month?
1,000.
And how many people in your home do you support as your dependents?
3, but it's not full time.
Not full-time? Okay. Okay. All right, you're a little over the threshold here. Are you unable to hire an attorney to represent you?
I'm gonna have to work something out, but I'll have to take care of that, Your Honor.
Okay. All right, well, for now, we'll indicate that you're gonna hire counsel. And let's see, I think our next available court dates will be November 25th. Make sure when you walk out of court that you check with the court clerk to make sure that we have a good mailing address for you.
Okay,
And if you hire an attorney, they'll know what to do. They'll know the right paperwork to provide to the court and how to communicate with the prosecutor. And so I want to revisit that protection order. As you know, that is in play. I see that you did provide proof of surrender of some weapons, so thank you for doing so. And at this time, unless you have any questions, I believe that concludes your arraignment today.
I do have a question, Your Honor.
What is that?
For the protection order, it's been filled out for a waiver of investigation or prosecution. And I think a couple other more documents have been provided to the court from Jessica.
Yep, and I see that she did visit the Domestic Violence Center of Grace Harbor. And she did on the 20th complete waiver of prosecution. That has no influence over my decision making. That's a prosecutor's decision on what to do with that. And because of how new this case is, I'm going to set the motion, the protected person's motion to modify the order. I'm going to set that on November 25th as well. It's my standard policy that in the infancy stage of a case like this, I like to give a little bit more time before I make a decision on whether to modify.
Okay.
So when you talk to an attorney, you may want to discuss some proactive steps that you can take as well that might influence the prosecutor in my decision making regarding that order.
I understand.
Okay. Well, that concludes your arraignment today, and we will see you back November 25th.
Thank you.
Thank you. Oh, did I get that wrong? Okay. All right, Mr. Duncanson, I don't believe I have anyone else here for arraignment today. So if there's cases you'd like to call that are ready,
Yes.
I'll let you do so.
One to call a little bit out of order just because he has a kid he needs to go pick up from school is Travis Roberts. Okay.
All right, the court calls for Travis Roberts. And you are Travis Roberts?
Yes, Your Honor.
Okay. The case comes on for pretrial today. Mr. Duncanson, how are the parties proceeding?
Yes, so I've been speaking with Mr. Rhodes. I'm not sure we'll be able to get a resolution in this matter. So I would just maybe ask for a trial setting at this time. I understand that the trial might be a little ways out just because of COVID and everything.
Would the city like to be heard on this matter?
Only, Your Honor, to say that if we set this for trial, I'd request a readiness hearing or some type of additional pretrial hearing before the trial.
Okay,
We were going to basically request the same.
all right. And we had continued this last month. Or wait,
It's been continued a few times.
few times. Where are we at with speedy trial, Mr. Duncanson?
I believe he signed a waiver a couple months back.
Yeah, we're gonna need a new speedy trial waiver.
Okay. I was
So
gonna
I
ask
know-
about, I was gonna ask about that. I wasn't sure what the court's current policy was on speedy trial.
I'm starting to put it back into play, and so if we're going to do a trial setting with a readiness hearing, we'll need a new waiver of time for trial right. And I'm looking at setting a readiness hearing December 28th.
Does that work for you?
I don't know.
Could we maybe do the readiness in January, just because that's right around Christmas time and
I'm supposed to be in Louisiana on 2028.
We'll have a readiness hearing January 25th with a trial date in February.
okay, I will set the new commencement date as February 1.
Okay. All right, well, with the filing of that speedy trial waiver, we'll continue the case. Mr. Roberts, make sure that you stay in touch with your attorney so he can prepare and you can help him prepare for trial if this thing does go. So we will see you back here in January at a readiness hearing with a trial date in February.
Yes, Your Honor. Thank you.
Okay,
Next matter ready would be Randy Elliott.
all right, the court calls for Randy Elliott. And you are Randy Elliott?
Yes, sir.
We're here for pretrial today, Mr. Duncanson. What are we doing?
Yes, we have a resolution in this matter. I believe Madam Clerk should be bringing in an SOC for your review. The resolution is a 24-month SOC to a reckless driving, along with standard DUI conditions, $550 fine. I've gone over the document with Mr. Elliott. He understands all his rights and the rights he's given up by signing this agreement and what happens if he complies and what happens if he does not comply.
Okay. Mr. Duncanson, I don't see,
Did I not have him initial the,
no, they're not,
Checkbox.
he's not initial this document, so we'll need to get initials on this prior to his leaving, but I'll go through the document now.
okay.
So Mr. Elliott, I have before me a statement of defendant on submittal or stipulation to facts, jury trial waiver, and speedy trial waiver. Do you know everything that is included in this agreement and you
Yes, I
understand
do.
it?
Yes, I do, Your Honor.
All right, and the city's agreed that if you meet the conditions, the charge upon successful completion will be an amendment to reckless driving. That's your understanding?
Yes,
Okay. And so we have an agreement whereby the case will be continued 24 months. You're agreeing not to have any criminal violations of the law during that time. You've agreed to obtain chemical dependency evaluation within 60 days and begin any recommended treatment within 90 days. You're also agreeing to attend a victim impact panel, pay $550 in court costs in 60 days, or begin making payments towards that fine. And you're prepared to meet all these conditions?
yes, I am, Your Honor.
Mr. Rhodes, is this all correct?
That's all correct, Your Honor.
All right, well, I've signed off on the parties' agreement. I find that it's in the interest of justice. Mr. Elliott, before you leave, wait for the court clerk so we can get your initials.
Okay.
And that concludes your case. Thank you.
Thank you, Your Honor.
Next matter ready is Delaney Norris. And we have a resolution in this matter as well that I will have brought back to your honor shortly.
And
Right.
where is that found on the docket?
Um,
Oh, here we go. I've located it.
at page 4.
All right, looks like we have 3 cases. Ms. Norris is cited with DUI and then some infractions along with that and minor possession or consumption.
Yes. The resolution, Madam Clerk is bringing it back to you now. The resolution is the city is moving to amend the DUI to a negligent driving in the first degree. Dismiss the MIP, and then she's going to answer committed to both infractions.
Okay. Where is the judgment sentence? All right, you are Delaney Norris?
Yes, Your Honor.
Okay. Ms. Norris, it's my understanding the prosecution will be amending this charge from DUI to negligent driving first degree. Mr. Rhodes, is that correct?
That's correct, Your Honor. The city so moves. One point that Mr. Duncanson and I did not have time to talk about this morning, to the extent it makes any material difference here, there is DUI restitution requested in the amount of $653.91. I don't know that Mr. Duncanson had an opportunity to discuss that with his client.
I did not. So if maybe we could just leave the restitution to be determined, and you might be able to have a separate order or a hearing if necessary on that.
Well, this is an amount certain based upon law enforcement responses to the accident, I believe. And I have the forms I can submit immediately to the court. So it's essentially a non-negotiable amount.
Are you fine with that?
On top of the 5.
It'd be payments
Okay,
again.
then,
Then we don't have a problem with accepting that amount.
Okay, Mr. Rhodes, that amount again was,
653.91.
okay. So Ms. Norris, you understand the rights you have in this court and the rights that you will give up upon entering a plea of guilty today, correct?
yes, Your Honor.
And the charge has been amended. It carries a maximum of 90 days in jail and a $1,000 fine. The parties have an agreement outlined in the plea form. And you understand I don't have to follow that recommendation?
Yes, sir.
And to the crime of negligent driving in the first degree, how do you plead?
Guilty, Your Honor.
And is this a free and voluntary plea?
Yes.
All right, I've read the statement of facts. I find that they're in order. Your plea is accepted.
I tried messing with it. Almost
The
fell.
party's ready for sentencing today.
Yes.
Mr. Rhodes?
Your Honor, these were serious occurrences. There was an accident that occurred. I believe that Ms. Norris is young enough that she will either learn her lesson and you will never see her again, or she will be back, in which case this will be treated like a prior and dealt with as such.
All right. Ms. Norris, you have a right to make a statement before I sentence you today. Is there anything you'd like to say?
No, Your Honor.
Mr. Duncanson,
I would just say that ask the court to follow the recommendation, and I would say more likely than not, Ms. Norris has learned from this incident, and we will never see her again, or any other court for that matter.
all right, I'll follow the recommendation of the parties. The charge of minor in possession or consumption is hereby dismissed pursuant to the agreement. And Ms. Norris, you intend to admit to the 2 infractions you were cited with? Is that my understanding?
Yes, Your Honor.
Do you have a valid license now?
No.
Okay. Mr. Duncanson, anything you'd like to say regarding those infractions?
No. Just maybe ask that the court mitigate it to the extent possible, as there is over $1,000 in fines on the neg.
Correct. Let's just take the infractions quickly. The driving with wheels off roadway, I'm going to leave the penalty set at $139. Operating without a license, I'll lower that fine from $553 to $180. I'm imposing a fine of $550.
For DUI, it's not that bad.
I'm going to impose the restitution amount of $653.91 for the response. And I'll have my court clerk calculate the total amounts with the required assessments and conviction fees. So Ms. Norris will have a total. Has there been an evaluation done yet?
I do not believe an evaluation has been done yet. I've referred her to stop, and she knows to get that done. If you have trouble getting a hold of stop, give me a call. I got other places I can send you. I've also explained the victim impact requirement to her as well, and where she can go to get that done as well.
Okay. Is this a new form? Is this a new form? Sorry, I'm just going through this form and I think there's some things that may have changed, so I want to make sure I get everything. In addition to the fine, you will be on unsupervised probation 24 months. You're going to obtain a substance use disorder evaluation, and within 60 days of you're going to complete that evaluation within 60 days and complete any recommendations within a subsequent 90 days. And so whatever is recommended, which I assume in your case will be a victim impact panel and alcohol drug information school, you'll need to complete those things. So even though you've wrapped up your case today, you do have outstanding obligations with this court. You understand that?
Yes, Your Honor.
Okay, I've signed the judgment and sentence. Good luck to you. Hopefully we don't see you back here again.
Okay, thank you.
Okay, anyone else?
Yes. Jordan Bryant.
I had taken Mr. Bryant's file aside here and was reviewing that prior.
I'll get you to initial. We do have this case resolved as well.
You do? Okay.
Yeah, which might resolve the no contact order issue. I'm just having Mr. Bryant initial because I also had him forgot to have him do that.
Okay, so it looks like case comes on for pretrial. I did read through the motion to modify. We'll address that. And so how is the case being resolved?
It's going to be resolved via an SOC, 12 months to dismissal, $250 fine, and he's to get mental health treatment.
Is there an evaluation on file?
No, not yet. He will get that. He'll get a mental health evaluation and follow the treatment. He's planning on doing that anyway. He's admittedly has some mental health issues that he's trying to work out.
Okay. Well, once I get that form, we can go through it.
It looks like Madam Clerk is busy right now, so I will just bring it back if that is okay with Your Honor.
That's fine.
Okay.
All right, Mr. Bryant, I've been handed a statement of defendant on submittal or stipulation to the facts, jury trial waiver, and speedy trial waiver. You've gone through this with your attorney?
Yes, Your Honor.
Good. You understand you're stipulating to the police reports, and if you violate the terms of this agreement, there will be a trial that will amount to me as a judge reading the reports and making a decision of your guilt or innocence. You understand that?
Yes, Your Honor.
And if this is revoked and you're found guilty of assault in the 4th degree, you would lose your right to possess, own, or control any firearms. You understand that too?
Yes, Your Honor.
And the good part about this is if you complete everything, the case will be dismissed pursuant to the agreement. The parties have agreed on a continuance of 12 months. During that time, Mr. Bryant, you are not to have any criminal violations of the law. And what is the agreed amount of court costs that it's left blank?
Oh, sorry, $250.
Mr. Bryant, you're prepared to pay $250 in court
Yes, sir.
costs?
Yes, Your Honor.
And you're to begin making payments or pay it in full within 60 days. You've also agreed to obtain a mental health evaluation within 60 days and start any recommended treatment in 90 days. Mr. Rhodes, is there anything else I might be missing?
No, Your Honor, I just asked the court to endorse this. I think the recommendation and requirements address the root cause of the issue here.
And we did, so I've signed that. And then is the protected party present today? That would be a Sydney Roush.
Yes, she is.
Okay. If Ms. Roush can step forward, we can address her motion.
Step away.
So Ms. Roush, I see that you did have contact with the Domestic Violence Center at Grays Harbor. Did you obtain some helpful information?
I
through
did,
that?
Your Honor. I did.
And I've read your motion and your affidavit. Anything else you'd like to tell me?
I recently reached out to a new doctor who gave me some mental health medicine to try and referred me to their psychiatrist.
Okay, I found what I was looking for. All right, so I'm going to grant your motion, and the protection order dated September 3rd of this year will be terminated.
Thank you, Your Honor.
All right, I've signed that order. We'll need to get your signature on it as well as Mr. Bryant's attorney's signature. You can obtain a copy of that order from the court clerk, and that concludes the case today.
Thank you, Your Honor.
Thank you.
There. Next matter would be Richard Newman.
All right, the court calls for Richard Newman.
Your Honor.
Okay, I have my file. Comes on for pretrial today.
Yes, I've spoken with Mr. Rhodes. I'm not sure we'll be able to resolve it at this time, so I would just ask that we set it for trial.
Good. Does the city wish to be heard?
No, only to the extent that we request an intervening hearing prior to trial.
All right. Well, I'll do the same thing I did in the other case. If we set for trial, we'll have a readiness hearing January 25th of 2022 with a trial setting sometime in February. My court clerk will get that date out and to the parties so we know the date that the trial will be heard. Mr. Newman, make sure you have your attorney has a good contact information number for you so he can prepare for trial and make contact with you. I believe that takes care of all matters other than where are we at with speedy trial, Mr. Duncanson?
I believe we'll probably need a waiver. It looks like he was arraigned probably August, so.
Yep, the court has no trouble continuing this matter with the filing of the time for trial waiver.
February.
January 25th. Okay, and I've had him sign a waiver for time for trial with the commencement date of February 1st.
Okay. Well, Mr. Newman, that concludes your case today. Please sign for your court date and we'll see you back here in January.
Have a good day, sir. Your Honor.
Thank you.
Give me a call between now and January, and we can set up a time to. Yep. Next matter ready would be Jesus Orozco Pacheco.
Court calls for Jesus Orozco Pacheco.
Hello.
Hello. Let me locate it on the docket. All right, Mr. Duncanson, Mr. Rhodes, the case is on for pretrial today.
There should have also been a motion. It was filed last month, continued to this month for the no contact order.
I see that in the file.
I'm not sure if the protected party is here today for that. I remember last month you had indicated you might review it and potentially sign off on it ex parte or
Mhm.
not. My client would like the motion to be heard today just based off of his wife's affidavit and also the court's knowledge that he has went and gotten domestic violence counseling and has.
I did review the evaluation. And so has your client begun treatment?
I don't believe he's begun the treatment as he recently lost his job, but he is getting on to unemployment, and I believe he's planning on starting next week, right?
Monday.
Monday. He did some like substance abuse, keep the
Yes.
treatment order too.
I'm doing that right now.
And he's also currently doing substance abuse treatment, as I believe that was part of the cause of the incident as well.
Mr. Rhodes, does the city have a position on this?
On the request of the motion to modify the no contact order. I don't, Your Honor, only because I've had no contact with the victim, and so I don't have I'm not opposing it. I also don't have any information to support it.
So she did file a motion back in September. What I don't see is that she's had any contact with the Domestic Violence Center of Grace Harbor. I did review the confidential evaluation that was submitted.
My client does indicate that he believes she did contact the domestic violence shelter. And also he's indicated that prior to the incident, they were planning on starting couples counseling. And I believe that's still the intent once the no contact order is lifted.
Okay. Well, for now, I'd be inclined to modify the order to allow the two to attend counseling together. But other than that, at the moment, I would like to have the petitioner in court so we can speak with her. Also let Mr. Rhodes. Is it too important that you can't listen to me talk?
So, sorry, he was indicating that she might be outside, but I'm not sure. Sorry.
All right. Well, like I said, I'll modify the order to allow for counseling and next month, maybe she can be present and be heard. So I'll modify that order, Mr. Duncanson. You'll need to give me a few moments to do so, and we'll get a copy of that to your client.
Okay.
Okay. So give me just a moment here. All right, Mr. Duncanson, I've modified that order to allow the two to attend counseling together.
Okay.
And I've also indicated on this modification that your client's not to consume any intoxicating beverages or drugs not lawfully prescribed.
Okay.
All right. Yes, and that concludes the case today.
All right, thank you. But step right over there for your, yep, step right over here for your court date.
Okay, do you have any other matters?
Lonnie Miller.
The court calls for Lonnie Miller. You are Lonnie Miller?
Yes, sir.
All right, this case comes before the court today on a pretrial conference.
Yes. This is one, it's kind of old at this point. We've been trying to do civil compromise. His insurance has accepted the claim, but he's having a hard time getting a hold of PUD and not sure what the holdup is at this point. He's called the PUD a couple times since the last court date and has left messages and haven't heard back from them yet.
Okay.
Insurance company's just waiting for, the insurance company's just waiting for PUD to send their bill.
I would maybe just
Well,
ask,
what are the
All right.
parties proposing today?
I would just maybe ask for a continuance, see if we can't maybe light the fire under PUD's feet to get the bill over, because then they can get paid. I'm sure they would like to be paid.
I have an email in the court file that says from the PUD that the calculated amount owed is an amount of restitution that appears to be $2,208.09.
Yes,
Correct.
and I believe what his insurance is waiting for is a bill directly from PUD saying that
I
they
see.
won't accept the bill that PUD has sent my client.
Because they sent me that email too, and I forwarded it to my insurance and they said, no, we have to have a physical bill from PUD.
Okay,
Your Honor, I've been communicating with PUD on about September 29th. They indicated the insurance company said, sorry, they missed a step in this and they're backtracking. They should get payment shortly. I've asked PUD to inform me as soon as they receive that payment, and they have assured me they will.
Okay, well, let's go ahead and set this over to our next court date, November 23rd, and hopefully the case can be disposed of at that time.
Yes, that is our hope as well.
All right, Mr. Miller, stay in touch with your attorney and we will see you back here next month.
Just sit over there. And I believe I have one more pretrial matter ready. That is Calvin Smith. He's on Zoom.
If he is, I can't see. Oh, there he is.
Just added.
All right, we've brought someone into our courtroom with a screen name of Calvin. If that's Calvin Smith, would you please unmute yourself and turn on your video? Mr. Smith, are you there? We can see Mr. Smith, but I don't think we can hear him. Do you have your microphone on and not? Sometimes you have to turn your actual microphone on.
Yes, Your Honor, I got it finally.
There we go. And you are Calvin Smith?
Yes, sir.
All right. We have two cases or two charges coming on for pretrial today, Mr. Duncanson. How are the parties proceeding?
Yes, so I talked with Mr. Rhodes. Mr. Smith has been working on getting his license back. At this point, he has one thing holding him up, one warrant he needs to quash. I've talked with Mr. Rhodes. I believe we have a resolution. I've emailed it to Mr. Smith once I got it from Mr. Rhodes, but I have not heard back from him yet. So I would ask for a 1 month continuance. I will say I believe this resolution, if Mr. Smith gives me a call and we talk about it, might be able to be signed off the record. It's just amendment to infractions and everything. So.
Okay. Mr. Smith, did you catch all that?
Yes, Your Honor.
All right. How much time are you asking for, Mr. Duncanson?
Just 1 month.
All right. I don't see any problem in doing so, but we will need a speedy trial waiver from your client, Mr. Duncanson.
Okay. And I will email one over to him today and
Okay.
get it back.
All right, Mr. Smith, we're going to reset your case and that'll come on November 23rd.
Okay.
So stay in touch with your attorney. It sounds like he sent you something for review. And we'll see everyone back here in November.
All right. Thank you.
Thank you.
And I believe that's all of my clients that are present in the courtroom and on Zoom.
Okay, I did see we have a pro se matter. So Mr. Duncanson, if you want to step aside, I'm going to call a case.
I will also just note, so you're aware, Your Honor, Doug Zimmerman is present in the courtroom, and it appears Mr. Arnold is on Zoom.
Okay. Will James Nations please come forward? All right. Good afternoon. You are James Nations?
Yes, sir.
Okay. Mr. Nations, you're representing yourself, and it looks like you and the city attorney have come to a resolution.
Correct.
I have a statement of defendant on submittal or stipulation to the facts. Did you read over this yourself?
I did, yeah.
And you understand you're stipulating to the police reports, you're gonna give up the rights that you have in this court. And if you meet all the conditions, the city is agreeing to dismiss the charge. That's your understanding?
Yes, Your Honor.
And so the parties have agreed to set the case out for 24 months. Mr. Nations has agreed to maintain law-abiding behavior. And he will not engage in any behavior considered to be by law as domestic violence or assault. And Mr. Nations, you've agreed to obtain an anger management evaluation within 60 days. And if any treatment's recommended, you're to begin that within 120 days of filing proof of that. And you're prepared to do so?
Yeah, I've already proceeded with doing so.
Okay. And you are agreeing to pay court costs in the amount of $300.
Yes.
All right, well, I find that this is in the interest of justice. I've signed off on it. We'll get you a copy of this so you have it for your records, Mr. Nations. And it looks like you've done a good job for yourself here, so thanks for taking care of business.
Thank you.
All right, we'll bring out a copy of that order for you.
Okay, thank you. Have a nice day.
Thank you.
Your Honor, just for the record, that agreement was entered into after significant discussions with the victim in this matter.
Okay, I assumed as much. Okay, I have a sentence compliance for a Todd Meadows. Is Todd Meadows present? And it appears, is that Mr. Meadows that stepped forward?
Yes, Your Honor.
Okay. And have you finished up treatment or are you still going?
I have just a couple more left. Last month, Josh had a family thing that went on. So
Okay.
there was a like a few weeks where there was no class. And then they switched it to in the building, and I wasn't informed on that for that last week. So, but I've been done them all of this month. So I have like 4 or 5 more.
All right. Mr. Meadows, I'm just gonna set this on for internal court review on November 23rd.
Okay.
So as long as we have those treatment reports, great. If there's a problem, be sure that you reach out to my court clerk and let her know what that problem is.
Okay. Thank you.
Okay, so you don't, as of right now, you don't have to appear. We'll
Okay.
just look for those reports.
All right. Sounds good. Thank you.
Thank you. Mr. Duncanson, you are representing Mr. Zimmerman, or is that, no, that's Mr. Arnold. So let's go ahead and bring Mr. Arnold into the courtroom. Mr. Zimmerman, you can come forward.
Hello, Your Honor.
Good afternoon, Mr. Zimmerman. And we're just waiting for your attorney to connect. It appears that you might be having some difficulty here. All right, well, while we wait to see if Mr. Arnold is able to connect, Mr. Rhodes, do we have a resolution today, or what do you know of the case?
No, Mr. Arnold and I have discussed the case as recently as today. My understanding is that we do not have a resolution today. I believe Mr. Arnold will request continuances of both matters.
Okay, well, it looks like Mr. Arnold is with us now. Good afternoon, Mr. Arnold.
Good afternoon, Your Honor.
All right, present in the courtroom is your client Douglas Zimmerman. And how is this case proceeding?
Well, Your Honor, my understanding is it's probably going to need a trial setting. I don't know what COVID has done to the court schedule. I do anticipate a few motions will most likely need to be filed in the interim before we get to trial. And obviously witness list needs to be exchanged and things of that nature. But
Okay,
yeah, we would request a trial date at whatever the court's schedule and discretion is.
okay, what we've been doing is setting a readiness hearing for January 26th, and then the court clerk's going to see what we have available for trial dates. And this will be, I believe, the third case now that we've set today. So if a case is going to go to trial in February, and we have 3 set, I will be taking the oldest case first.
I don't
So,
object to that, Your Honor.
okay. And I think we may need a time for trial waiver too. And you have a good way to reach your client?
Yes, if that question is directed to me, yes, Your Honor, I do.
Yes, it is. So you'll want to get in touch with him and explain speedy trial, because if we're going to set this case and not have readiness until January 18th, we'll need a speedy trial waiver.
Very well. If he's in the courtroom, I can, and if he's willing to wait a few minutes, I can go there in the next 5 to 10 minutes. If the court
Okay.
has those forms in the courtroom.
We do, and that's fine. Mr. Zimmerman, are you able to wait a few minutes for Mr. Arnold to come into the courtroom?
I am, Your Honor.
Okay. Well, that concludes the case today. We'll look for that speedy trial waiver, and we'll see everyone back here in January.
All right, thank you, Your
Your
Honor.
Honor, just one clarification. There
Sure.
are two cause numbers here, and just to be very clear, I think we'd be talking about separate trials in both cause numbers as they're
Sure.
unrelated matters.
Right, and we would not be joining these for trials. They're unrelated facts. So,
Very good. I do anticipate possibly a resolution in the trespass 2 matter, Your Honor, but the other matter, I do not.
okay. All right, well, I'll let the parties figure that out for themselves. And cases, both of them are set over to January 18th with a confirmation date.
Thank you, Your Honor.
Okay, thank you. All right, Mr. Rhodes, did, and you may have received it too. The court received an email from defense attorney Carrie Young. Did you see that email?
I saw that, Your Honor.
Okay. Apparently he is in custody in the Grays Harbor Jail. And she believes that she has a conflict. And so, Mr. Duncanson, did you have a conflict with this case as well?
Which case is it?
City versus Cameron Combs. I'm guessing there probably was a conflict if we appointed Carrie Young as conflict counsel.
Yes, I believe he might have been victim in another case of mine, I think.
Okay. All right. Well, I'll remove Carrie Young from her appointment. And we'll go ahead and appoint Jeff Arnold. We'll get the attorney's contact information to the Grays Harbor County Jail. I'm not sure how long it's anticipated that he will be held in custody. So we'll just note his absence on the record for today. Oh. Hang on. All right, do the parties have any other matters to hear today?
I'm not aware of any more pro se matters or any other matters, Your Honor.
There is someone in the courtroom. I don't believe she's my client. What are you, what's your name?
My name is Julie Porter.
Julie Corver?
Porter, yeah. And it said in my papers.
She wants to make a request
I wanted
on her admission, or not
ask
on
about moving.
electronic monitoring. She has a list of things that she wants to be able to do. I told her she needed to come and talk to you.
Okay, so is Julie Corver present?
Yes, she is.
Okay, you are Julie Corver?
I am.
Okay. Are you still represented by Robert Earhart?
No, he withdrew because there really wasn't any reason for him to keep on.
Okay, and so you filed what appears to be a request to modify electronic monitoring, is that correct?
Yes, and then I also, I've already talked to Kay about it, but a permission to move to Tacoma.
Did you notify the prosecutor with this request?
No. didn't
Mr.
know.
Rhodes, have you been provided a copy?
They have not seen one yet, Your Honor.
Okay. Um, Well, Ms. Corver, this is quite an extensive list of accommodations you're asking for. How much time do you have on electronic monitoring?
6 months.
Okay,
And like, and if I move, I don't need to go to the store because I'll actually have a full-size refrigerator.
I don't believe there's any restriction on you moving out of the area to Tacoma.
Okay, that's awesome. I'm
So
so
yeah,
excited.
you're free to move where you want.
That's great. I'm so excited.
And so regarding the rest of these requests, we'll need to get a copy of this to the prosecutor so we can get input from the city on these requests to make amendments.
Okay.
All right. So Mr. Rhodes, my court clerk, will get that to you and we'll set this on next month on November 23rd and we can address these requests.
Thank you, Your Honor.
Okay. Thank you. And that concludes your case today.
Thank you, Your Honor.
Let's see here. I'm going to go through some of these arraignments. You do? Is this person here?
It's just a contested hearing, but he lives in Seattle. So he was gonna Zoom.
Is he
Zoom.
in there? Okay, you can bring him in. Mr. Rhodes, I was just made aware that there is a contested infraction that is set today. And we're going to bring this person into the courtroom. All right, can you identify yourself for the record, sir?
I'm Alex Babajonov.
Okay.
I don't know, you didn't mention my name, so I'm not sure if you're talking to me.
I'm talking to you. Yeah, I wanted you to pronounce your name so I could hear it said correctly.
Gotcha. No problem. I just
All right. So
Alexander.
you've requested a contested hearing today. Did you request the officer's presence?
One second. I was watching the YouTube, so the sound is coming in different. I just turned it off.
Okay.
Yes, I did request the officer's presence. And I'm really sorry that we had to reschedule a few times. The Zoom I wasn't let in last time and dragging
Not-
along.
I'm seeing that you signed your ticket requesting a contested hearing. And on that form, it states you can request witnesses be subpoenaed, but I don't see anything specifically requesting the officer's presence today.
Okay.
And do you intend to proceed with a contested hearing today?
Yes.
Okay. So I have the affidavit of the officer. Before we have the hearing, do you have any preliminary motions for the court to consider?
No.
Okay. Mr. Rhodes, is the city planning to enter Officer Colgren's affidavit as evidence at today's hearing?
The city appears via affidavit of the officer that the court has on a file.
Okay. And so I'm going to allow the affidavit of the officer to be entered. Sir, I will take your testimony first, and then I'll review the officer's affidavit and make a decision. This is a civil hearing, so the standard of proof on the city is a more probable than not basis. And so if you'll raise your right hand, I'll swear you in. Do you swear to testify to the truth and nothing but the truth?
I do.
Okay. Well, now is your chance to testify. Once we have your testimony, I'll read the officer's affidavit, and then if there's any closing argument, I'll hear that too. So the floor is yours.
Please forgive me for I don't have representation. It was very difficult to find anyone to take it in this county. So I'm fairly amateur in this situation.
That's fine. Now's the time for you to testify.
Thank you. I have the affidavit of the officer that I received from Kay electronically. I wanted to understand why there was no information on how the serial number of that radar was checked, and in the past records of the, I mean, I have the, I don't know if you could, oops, I don't know if you could see on the screen. Gosh, it's blurry. But I'm sure you have this copy, but it's on the middle of the first page, the 2001 with model vehicle number custom that down on the paragraph below says this unit was checked and utilized an internal and external circuitry test. I have no information on that, and nor was that provided to me. And I'm fairly certain that the officer on the citation marked going 5 over the speed limit. In his affidavit, he's stating that I was traveling 20 over the speed limit. All that information together tells me that either there was some reading that was not proper, and there was just, something that had to be done at that time. And I was not going to argue with the officer at the situation. So that's what, based on that, I'm requesting a dismissal.
Okay. Well, let me take a quick read through this. And what I will say about getting you at a higher speed than cited for, many times officers will lower the speed to lower the fine. So that's probably what he did here.
I didn't even notice that when he even brought it to my attention. I only noticed it in the report.
Okay. Well, that's kind of a distinction without a difference, but I'm reading through the officer's affidavit. He was using the unit in stationary mode using the rear antenna. He says he checked the radar before and after his shift using 2 assigned tuning forks. But where I'm lost, we have the certifications on file as public record, but there's no indication here of the tuning fork, the 2 tuning fork numbers, which would have been used. And so I'm going to suppress the speed reading in this case. And with the suppression of the speed reading, I will grant your motion to dismiss, and the case is dismissed.
Thank you. Thank you, Your Honor.
Thank you. That concludes your case.
Have a great day. Do I need to do anything with Kay at this point, electronically?
No, it's been dismissed, so you're done. All right, well, I'm going to go through the arraignments, Mr. Rhodes. The court's calling for Casey Baglinger.
There's no one in the courtroom, Your Honor.
All right. Then what I'll do, I'll just review these off the record and make decisions on warrants. Mr. Rhodes, do you have anything else for the court today?
I don't. Thank you, Your Honor.
Okay, thank you. And Mr. Duncanson, if he's in the courtroom, he's free to go as well.